Hi, my name is Matt Wadsworth, and in the next 2 minutes I'm going to discuss with you fault and fidelity in divorce cases. Well, I'm going to answer the question about infidelity or fault in a divorce case in the state of Utah. And in Utah, it's a no-fault state for purposes of divorce. And what that means is that one party doesn't have to breach what we call breach the divorce contract in order to be awarded a divorce in the case. It's kind of funny to think that way, but I mean historically, when you filed a petition to get a divorce, you had to say why. And then you had to prove the facts relevant to the why. And if you did, the court would grant you a divorce and then deal with all these other issues that you were arguing about along the way, such as property and alimony and child support. And we don't really do that anymore. It's irreconcilable differences. That's why everyone gets divorced these days. It's easy. There's like virtually no standard there. But infidelity and fault, though, now, and this just happened recently, is a consideration for purposes of alimony. And it comes into play. And it was actually a big battle within the divorce attorney world. It was a big battle in the legislature. And in my opinion, it really shouldn't be. If you have a party that has breached or whatever, I mean that's a consideration. What's funny though is that so often in divorce cases we find that there's all types of fault to go around, and that's generally where these arguments end up going. I will say though, as a matter of experience, that courts are still a little leery of considering fault, even infidelity of any kind, for purposes of alimony. And so that's just the nature of the beast. That's where we're at these days. It may change down the road, and that's just where we're at. If you found this information informative or you have other questions, we have a catalog of videos that are there to answer some of the most common questions that we have in domestic litigation cases. Feel free to contact us at my personal email, wadsworth@arnoldwadsworth.com. You can also reach my partner at arnold@arnoldwadsworth.com, or you can feel free to call us anytime. Thank you.
Power of attorney it's a device by which you can appoint somebody else to manage your affairs if you are unable to do it for yourself, or just to help you manage your affairs if you can only manage them to an extent yourself. Until 2007 you could only make what was called an enduring power of attorney, and anybody who did those are still valid. You just can't make a new one of those anymore. Those dealt only with money and property. It wasn't possible to make a power of attorney to deal with your medical decisions and welfare, where you should live, for example, if you needed to go into a nursing home. So there was in 2007, two sorts of powers of attorney were set up. They're both called lasting powers, but one's a lasting power for your property and affairs, so rather like the old EPA, enduring power, and the other one is a lasting power for health and welfare. And the beauty of them is that you can appoint the person or people that you would choose to manage your affairs if you can't do it anymore, rather than, if disaster strikes, let's say you had a stroke, can't manage your affairs, maybe only for a few weeks, but during that period somebody has got to keep the show on the road. And the alternative to you having an attorney is that somebody will apply to the court for a deputy to be appointed. That's what used to be called a receiver. That might be a member of the family, it might be a family solicitor, it could be a panel deputy. There are 60 of those around the UK, or England and Wales I should say correctly, of whom I'm one. The nice thing about a power of attorney is that you can choose for yourself, and it can be a member of the family, professional, combination of those if you feel that there are issues that a member of the family might need a hand with. And the attorneys, the way you make a power of attorney is that you fill in a form, basically. You can download them from the intranet if if you want to. You can get them from government site, the courts site. People do get in a tangle with them. There's quite a lot of bureaucracy attached to it, and you do need to make sure that you've got every I dotted and every T crossed in exactly the right place. You have to pay a court fee of £130 for registering power once you've made it at the Office of the Public Guardian, who then keep a light hand eye on things to make sure that nobody's doing what they oughtn't. And once the power is registered, the attorneys can then act, provided that the person who's given them that power is happy for them to make the decisions and can't make the decisions themselves. So to the extent that a person can make their own decision, they must be allowed to do that. You can just confer with them. If they really can't make the decision, then it's up to the attorney to make a decision in their best interests. Quite often people will appoint different attorneys for their property and affairs. Ideally you want somebody with a good financial head on their shoulders, from the people who might make the decisions about which nursing home they would go into, for example. It's more likely to be a close member of the family for that. Or should you be revived? If you're in a coma with no prospect of a quality of life after being revived, is that what you want? And who's going to tell the doctor what you want? And that would go into your health and welfare power. So it can be pretty extreme in what it does, but you can control how much power you give your attorneys within the document as to what decisions you'd like them to make, whether you want one or more people to make a decision, or whether you're happy just for one to do it. You can also appoint a backup attorney, so if you appoint somebody who then dies or goes off the rails or disappears abroad or whatever, you can have a backup attorney come in and take over. So they're good and flexible. I mean, my view, I think everybody should have one. People will say, oh, but I'm not old enough. But, road accidents happen, sadly. Illness happens, sadly. And, just because you're 20 doesn't mean to say it's not going to happen to you. Just because you're not wealthy doesn't mean to say that you don't have affairs that need managing. I've got a young lady, very young lady, who had a difficult time at birth. She's on benefits, she can't manage them, so I get to do that, to give her a hand with how to manage things and where she's, to help her with where she's going to live and so on. So it's a good flexible system.
This is a 3-step guide to ensuring your will is properly signed. We all know the importance of making a will. It gives reassurance that everything will be in order for our loved ones when we pass on. What is not so well known is that if a will is not properly signed, then that will can be invalidated. Help make sure this does not happen to you and your loved ones by ensuring your will execution procedure follows these 3 steps. 1. Read the will carefully and make sure that you understand its effect. 2. Sign and date the will in the presence of 2 independent witnesses using a normal signature. Both witnesses must be present at the same time. 3. The 2 independent witnesses sign and provide details of their full names, addresses and any occupations. Once completed, the will is valid and will take effect when the maker of the will passes from this world. Witnesses can be any adults with full mental capacity, but should not be beneficiaries in the will, or the spouse or civil partner of a beneficiary. Please note that this video is provided for information purposes and does not constitute legal advice. Find more information about this and similar topics on our website www.barellison.co.uk in the Wills and Probate blog.